Hello, this is Matt on the Moon Lambeau channel. I'm going to share with you opinions from two attorneys within the XRP community in this video, and one of them says that you may see settlement between the SEC and Ripple within 2 weeks, and I'll explain why this particular attorney thinks that may indeed be the case. And I tell you what, I would not mind seeing that in the least. And also, there's all sorts of other headlines legally. I pulled up a couple of them. I don't know that I'm going to run through all of these thoroughly. There's too much for one video if I do that, frankly. But let me give you a couple headlines at a minimum here. And this is all stemming, by the way, from Ripple's most recent filing of a legal memorandum. So here's one from Crypto Briefing. Ripple claims SEC misquoted it in latest development. Well, what do you know? The SEC... just effectively lie. That's what here's what the SEC does. They misdirect, they lie, they're hypocritical, and frankly, I don't think for a moment that they give a damn about the investor that they're supposed to be protecting. In their mission statement, it is very clear. Their mission is to protect the investor. I don't think they're doing that. And the degree to which they're proving their sliminess, these court tactics that we've been seeing for months now, I think that proves it just as much. Here's another headline from AMB Crypto. XRP lawsuit update. Ripple opposes SEC's motion to strike, citing cherry-picked facts. So there's plenty to talk about in this latest Moon Lambeau hot jam. But I do want to be clear at the outset that I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes YouTube videos as a very fun hobby about Ripple and XRP and cryptocurrency in general, but that is indeed all that's going on here. And so the two attorneys in question within the XRP community, having nothing to do with the SEC, nothing to do with Ripple, are Jeremy Hogan, who runs the YouTube channel Legal Briefs, and also John Deaton, who is the attorney that has filed to intervene in the SEC versus Ripple case, and we're still waiting to see ultimately how that pans out, but hey, fingers crossed at a minimum, right? And so it turns out that, according to Jeremy Hogan at least, that this case could hinge on whether or not the SEC is successful in having Ripple's fair notice defense stricken. And so the fair notice defense, it's this idea that, look, Ripple, they've been around for the better part of a decade, and they've been operating as a business, you know, for again, most of the last decade. And the SEC just allowed Ripple to continue conducting business as usual. They had nothing to say about XRP specifically. They did not provide sufficient guidance in terms of, really for the entire crypto asset class, any company working in blockchain, to indicate what would or would not be a security. And so the idea that Ripple should have known, given the lack of clarity, that what they were doing would be illegal by SEC standards later on, like that whole concept is ridiculous, because they didn't have fair notice back when this all began that this was actually legal. And frankly, that's because the SEC didn't even know that they were going to decide later on that it's legal. That's how ridiculous all of this is. And so this is a key piece of what's going on here. And so here's the deal. If Ripple did not receive fair notice from the SEC, then even if the court thinks that XRP itself is a security, it doesn't matter. Ripple wins. The SEC has a big burden of proof, so says attorney Jeremy Hogan. And that makes all the sense in the world. It's just, you know, imagine businesses going about business as usual, and then imagine a decade later they come back and make up some sort of new rule that says, oh no, you were breaking the law. It's like retroactive prosecution, like that. I don't that doesn't make a bit of sense in the least. And so that's why ultimately, if indeed it's the case that that Ripple did not receive fair notice, this thing's done. Completely done. And so at a minimum here, and that's not going to be determined right now, you know, assuming the court case isn't settled, that's when we'd find out, you know, the bigger picture of that. But what will be decided sooner than later is whether or not this legal defense that Ripple has put up will be allowed within court, because they might not even be able to legally argue it, but They probably will. Let me go on a little bit further here, though. Because look, frankly, there are two discovery motions that are pending. We're waiting to hear back from the judge on in terms of what the outcome of these things are going to be. And so the first one had to do with MOUs, which would be memorandums of understanding. And so this is the whole thing, you may recall, where basically the SEC is using its position of privilege to intimidate Ripple's actual existing customers the world over, because the governments of the United States and many other governments, frankly, they've set up a situation where they can require information be sent back and forth. Specifically, what's happening here is that the SEC is contacting whatever agency it would be in whatever other country, and I don't know that the specifics have gone out, but they're contacting whatever agency on a governmental level that has the power to compel businesses within their country to present information on their dealings with Ripple. And so this is outside of what the court allows, but it's not illegal. And so that makes the SEC look bad, but they seem to just not give a damn because they're a bunch of asshats, right? And so the companies over there, they just feel like they're getting bullied, intimidated, and it's very burdensome. They're having to comply with all sorts of stuff, and it's stressful. So that's not good for Ripple, the company, right? And so as it turns out, though, things are set up in such a way that the government agencies, per the agreement with the United States, like they have to comply. And so this information is being funneled back to the SEC when they shouldn't be able to have it in the first place. If they weren't the SEC, they wouldn't be able to get this information. And so we're waiting to hear if this is the information received and this is going to be discoverable. And so Jeremy thinks the judge will likely rule on Ripple's side because it's taken so long for a decision on this to be announced, frankly. If it were the case that the judge could rely upon a precedent to make a determination, this would have more so been a slam dunk for the SEC, but that's not what we're seeing. And so given that there wasn't a quicker response, they're probably taking time to draft up rationales to why there is no real precedent for this, and the thought process of all this and that. And so that's why he thinks that this is more likely not going to go in Ripple's favor. And then there's another one, the issue of attorney-client privilege. And this gets back to this whole idea that Brad Garlinghouse and Chris Larson and everybody at Ripple, they knew that what they were doing, that's the claim, that they knew what they were doing was wrong. They knew that XRP, because they were warned by their attorneys, they were warned that it could be considered by the SEC to be an investment contract that is to be sold as a security here. Now, frankly, from what I've seen to this point anyway, basically it seems to me that Ripple was warned that the SEC might make a claim which would be a bogus claim, which is they could come in and state, yes, this is what you've done, you've now sold XRP as a security. So there's always a risk that the SEC could come and do that. That doesn't mean that Ripple believed that XRP was a security or that the SEC would be right in making such an assertion. It does not mean that, right? And so it gets hairier, though, because Ripple was warned that the SEC could come and do that. And again, I don't think that means that it's a slam dunk. Oh, that's right. That means that XRP is now a security. No, it doesn't mean anything of the sort. Of course not. And so there's such a thing as attorney-client privilege because there were these private memos that were sent to, like, Chris Larson, for example, co-founder of Ripple, way back in the day. And so the information included in that shouldn't be discoverable except if they voluntarily gave that information out to other third parties, and then you basically waive that right. And so Ripple is claiming attorney-client privilege on all documents provided by their legal team dating back to the early days of Ripple that have to do with what their lawyers said on the topic of whether or not XRP might be considered a security by the SEC. However, the SEC claims that Ripple waived its right to confidentiality by sharing memos from their lawyers with third parties. So the SEC claims Ripple co-founder Chris Larson sent one of the law firm memos to third parties at least 14 times. And so Jeremy Hogan, anyway, he thinks that as a result, the SEC will win on this point, and the memos, which otherwise would have been protected under attorney-client privilege, and so it'll now be discoverable. That's what's likely to occur, he thinks, anyway, right? And so let's talk a little bit as far as this fair notice, because like this is a crucial part of this entire case, right? So here are a couple important notes on why Ripple's fair notice defense will likely stand. And this was covered in Ripple's most recent legal filing. So former SEC Chair Jay Clayton made public statements indicating that a significant concern that makes digital assets appear to be securities is when the asset offers, quote, interests in a yet-to-be-built system, end quote. And so this put all of the initial coin offerings of 2017 under a microscope. But XRP was created before Ripple existed. Think about that. And that's provably true, by the way. XRP was created before Ripple existed. So then, on that front, how was Ripple supposed to think that what they were doing could have at all been perceived by the SEC as been illegal? Like, why would they possibly think that, right? And so public statements, also, check this out, public statements by other members of SEC staff likewise distinguished between initial coin offerings and fully functional blockchain technologies. And this gets really cool here because attorney John Deaton, again, he's the attorney within the XRP community who's seeking to intervene in the SEC versus Ripple case, he was actually cited in Ripple's most recent legal filing on this. They literally put down, so what he has done here is positively, provably so, positively impacting this these pretrial hearings in the case, everything really, and it's fascinating. And so here we go. I had this in front of me here. Yeah, here we go. See Deaton. They can say what it is. Distinguishing between ICOs promising to create an innovative application of blockchain technology, which are suspect and likely securities and sales of cryptocurrencies only once the network is up and running after drawing initial funding from traditional sources, which likely are not securities. And that came directly from what Ripple filed. And so here, what they're saying, Ripple is pointing out that the sale of a cryptocurrency is different than an ICO, which the SEC led them to believe is a significant factor in whether or not XRP is a security, whether or not it's an investment contract. Because again, Ripple, they've sold an asset they own, which is XRP, but there was no initial coin offering, and it existed before Ripple, the company. Important points. And the SEC indicated as much. And then public statements by other members of the SEC. Oh, wait, actually, I'm sorry. Let me go down a little bit further in this. Yeah, okay, so, sorry, I got, like, the most recent... These documents are huge. I don't know if you guys have taken a look at this. Like, the most recent Ripple filing, it's like 34 pages or something. It's like, some of these are absolute... Some are shorter, but these things are absolute monsters. So, like, it's a lot to manage, especially for someone like me who doesn't have a legal background, and I'm not used to looking at all this stuff. It's, like, a lot to manage here. But anyway, Jeremy predicts, ultimately, Jeremy Hogan, predicts that we'll see a settlement between the SEC and Ripple within 2 weeks if it's going to happen. And so new SEC Chair Gary Gensler had his first SEC litigation review meeting the other day, okay? And if Gary wants the SEC to focus on regulatory clarity rather than regulating through enforcement, which is what the SEC has done up to this point, well then Gary would want the SEC to pull out of this fight. That's what he would do, and he certainly could push for that. We don't know if that's going to happen, but it's possible. Jeremy Hogan's just pointing out here, hey, if Gary Gensler wants to change course, you're going to see it within the next couple weeks. He's been briefed on what's going on. He's fully up to speed. He's doing his job. This would be the time for that to happen. But if we don't see it within 2 weeks, well, that would mean right there that, this is Jeremy's opinion now, that he wants to move ahead full steam with this, unfortunately, what is, regulation through enforcement. That would mean that this case would proceed at least for a while, at least through discovery. And so the soonest we would see a settlement, if we don't see it within the next couple weeks, Jeremy thinks that the soonest we would see a settlement would be September. because we need to get through discovery first, the whole discovery process. Because here's why. It won't be until that point is reached that each side knows what ammo the other side has. So if neither, like, so if based on communication that Ripple's had with the SEC to this point, like, they could not agree on settlement, the only thing that is going to change that is if they think the other side has the winning hand. Then you might see that. Outside of that, I don't think it's going to happen. Jeremy seems to not think it's going to happen, and that makes logical sense to me. So all sorts of stuff going on that front. Now, John Deaton also, he was asked about the fair notice defense and Ripple's fair notice defense and whether or not might be stricken, and he wrote the following. Ripple's response to the motion to strike its fair notice defense is a great read, and there is no way the judge will strike it at this point. Ripple has the facts and law on its side. And so that's two attorneys, Jeremy Hogan and John Deaton, that both think it's not likely at all that you'll see this defense, which is a crucial defense. I don't think that it's going to be chucked out the window. So that would be good. I would certainly hope that doesn't happen. But things looking good to this point. And like I've said in the past, if I were a lawyer, I would rather be in the position of having to defend Ripple than to have to defend the SEC's nonsense positions. Just saying. That's how I feel. But let me know what you think below. Do you think we actually are going to see a settlement that soon? I would really not mind putting all this crap behind us. So if that could just magically happen, yes, please. I would like that very much. I'll wrap up there, though. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.